For the record, How to Turn a Red Light Ticket Green and Save Thousands, published by Guidant Publishing, P.O. Box 1566, Bellingham, Washington, telephone number 6474871950, email address guidantbackoffice@gmail.com. Copyright 2025 by Thomas Paine and Guidant Publishing, printed in the United States of America, all rights reserved. ISBN 13-979-8-99-95258-0-2. Cover design by Thomas Paine, Library of Congress Control, number 20259-14844. Any characters and events portrayed in this book are fictitious. Any similarity to real persons, living or dead, is coincidental and not intended by the author. No part of this book may be reproduced or stored in a retrieval system or transmitted in any form or by any means, electronic, mechanical, photocopying, recording, or otherwise, without express written permission of the author and publisher. Unless otherwise noted, all materials, including but not limited to images, illustrations, designs, icons, photographs, video clips, software, and written and other materials that are part of this publication are protected under copyright laws and are the trademarks, trade dress, and/or other intellectual properties owned, controlled, or licensed by the author and/or publishers. You may read and use the material in this publication for your personal, temporary, non-commercial viewing only. No part of these materials may otherwise be copied, reproduced, stored, republished, uploaded, posted, transmitted, or distributed in any form or by any means, electronic or mechanical, now known or hereafter invented, without the prior written permission from the author or publishers. Table of Contents, Legal Advice Disclaimer, About the Author, Forward. Chapter 1, Understanding Red Light Laws. Chapter 2, The Ticketing Process. Chapter 3, Common Defenses to Red Light Tickets. Chapter 4, Gathering and Organizing Your Evidence. Chapter 5, Preparing Your Case. Chapter 6, Court Procedures. Chapter 7, Using Legal Precedents and Authorities. Chapter 8, Drafting Legal Papers. Chapter 9, Negotiating with the Other Side. Chapter 10, Here Comes the Judge. Afterword, Additional Online Resources. Appendix A, Glossary of Terms. Appendix B, Sample Forms and Templates. Appendix C, Sample of a Washington Motion to Dismiss and Memorandum of Points and Authorities. Appendix D, Washington State Useful Resources. Appendix E, Sample Generic Motion to Dismiss and Memorandum of Points and Authorities. Legal Advice Disclaimer. What the Lawyers Make Us Say. All materials in this publication have been prepared for general information purposes only. The information presented is not legal advice, is not to be acted on as such, may not be current, and is subject to change without notice. Communication of information by, in, to, or through this publication and your receipt or use of it, 1, is not provided in the course of and does not create or constitute an attorney-client relationship. 2, is not intended as a solicitation. 3, is not intended to convey or constitute legal advice. And 4, is not a substitute for obtaining legal advice from a qualified attorney. You should not act upon any such information without first seeking qualified professional counsel on your specific matter. This publication is not intended as legal or lawyer advertising or solicitation in any jurisdiction where it could be so characterized as such and fail to comply with all applicable laws and rules of that jurisdiction. The information presented in this publication is provided as is without representation or warranty of any kind. As to suitability, reliability, applicability, merchantability, fitness, non-infringement, result, outcome, or any other matter, no representation or warranty is made that such information is or will be always up to date, complete, or accurate. Any representation or warranty that might be otherwise implied is expressly disclaimed. By purchasing or acquiring this publication, you agree we are not liable to you or others in any way or for any damages of any kind or under any theory arising from this publication or your access to or use of or reliance on the information in or through this site, including but not limited to liability or damages under contract or tort theories, or any damages caused by viruses contained within electronic files of this site, or any linked site, regardless of prior notice to us. The scenarios set forth herein are dependent on the facts of the particular matters described, among other variables. Results will differ if based on different facts. No assurance is intended, and no guarantee or prediction is made of success in any matters, even if they involve similar facts and circumstances. Results described herein are not necessarily indicative of or similar to results in other matters. This publication contains summaries for general information and discussion only and are not full analyses of the matters presented and may not be relied upon as legal advice. About the author. Writing under a pseudonym, the author is a determined individual who, after receiving a red light camera ticket, set out to challenge and ultimately dismiss the citation. Drawing from the first-hand experience of how easy it was to overturn the ticket, the author has consulted attorneys, meticulously researched traffic laws, reviewed courtroom procedures, and uncovered the nuances of red light ticket enforcement. Through persistence and attention to detail, not only did he achieve a successful outcome, but also the creation of this book was inspired. With a background in advocacy and a passion for empowering individualism, the author aims to untangle and simplify the process of contesting red light tickets. Through clear explanations, practical strategies, and real-world examples, readers are provided with the tools needed to navigate the red light ticket system confidently. Outside of writing, the author enjoys helping others understand their rights, staying informed about changes in technology, and sharing stories of people who stand up for themselves. This work serves as both a guide and a source of encouragement for anyone facing consequences or challenges from a red light ticket. Forward. Thank you for choosing to listen to this book. If you find the content helpful or insightful, I would greatly appreciate it if you would take a moment to leave an honest review of this podcast on Spotify, Apple, Google Play, Amazon, Goodreads, and any other widely used book or podcast review platform you might choose. Your feedback will help readers discover this book and supports independent authors like me. Most people who get traffic tickets do not contest them and simply pay the fine, even when they know it could end up costing them thousands of dollars in penalties and increased insurance rates over the next few years. Less than 10% of recipients challenge red light tickets, but those who do often have a reasonably good chance of success. As of 2024, there were 333 communities operating red light camera programs in 25 states. Major cities, including Chicago, New York City, Philadelphia, San Francisco, etc., and smaller cities together likely issued around 4.2 million tickets nationwide in 2024. The average fine per ticket is estimated at $130, based on the range of fines $50 to $200 seen in various states and cities. Do the math. This estimate suggests that the total dollar value of fines for red light tickets issued in the United States in 2024 was approximately $546 million. This is a conservative estimate, as actual totals may be higher due to unreported cities, late fees, and variations in fine amounts across jurisdictions. In exchange for less than an hour of your time, if you are one of those drivers who gets a red light ticket, whether issued by an officer or in the mail by way of a camera, you could have a better than 1 in 3 chance of successfully challenging it after reading this book. The success rate for challenging a red light ticket in the United States varies by location and the type of violation, but available data and reports indicate that nationally about 30% of red light tickets are successfully contested. This means that across the country, nearly 1 in 3 drivers who challenge their ticket in court or through administrative hearings win their case, often due to technical errors, unclear evidence, or valid defenses. In some jurisdictions, the success rate is even higher. In Washington, D.C., about 80% of red light camera charges were dismissed for those who contested them, according to an analysis by the Washington, D.C. Examiner. For other moving violations, the success rate was around 60%. In the Bronx office of the New York City Traffic Violations Bureau, Drivers win or get moving violation tickets dismissed about 73% of the time when contesting officer-issued tickets, while the success rate for challenging red light camera tickets in New York City courts is more likely below 10%. Anecdotal evidence from other cities and states, such as Chicago, shows mixed results, with some drivers reporting dismissals, especially when evidence is unclear or lines are not visible, and others finding it difficult to win, depending on the judge or hearing officer. Why do the people win? We the people win because of A. Technical or procedural errors such as unclear photos, improper notice, malfunctioning equipment. B. Valid defenses such as the sign was obscured or it was an emergency, or the person cited was not the driver. Or C. Insufficient or unclear evidence is presented by the prosecution. When do the people lose? The government wins when they have clear photographic, video, or testimonial evidence, or because of strict legal liability in civil camera cases, meaning the owner is responsible regardless of the driver unless they can prove someone was driving their car without permission. One thing is for sure, it's heads you lose, tails the government wins if you don't exercise your right to challenge them to meet their burden of proof. Many people don't realize you can often successfully contest a red light ticket if you can prove any of the following. 1. You ran the red light due to a health or emergency issue. 2. You went through the red light because you were following instructions from law enforcement officers. 3. You ran the red light as part of a funeral procession. 4. The vehicle or license plate in the photos is not yours. 5. Your vehicle or license plate was stolen or transferred before the violation occurred. 6. If there are multiple vehicles in the photo, yours might not be the one that triggered the camera. 7. You can challenge the accuracy of the camera if you have evidence it malfunctioned at the time. Request the technician's certification as proof. 8. The traffic light was not working properly when the incident happened. Success rates are higher in jurisdictions where the process is administrative, the prosecutorial evidence is weak, or procedural requirements are strict. The average success rate for challenging a red light ticket in the U.S. is about 30%, but it can be much higher in some cities, up to 80% in D.C., and lower in others depending on local practices, the strength of your defense, and the type of violation. Red light camera tickets can have legal issues that drivers often overlook. When a driver is accused of running a red light, they typically have the right to question their accuser. This is feasible when a police officer issues the ticket, but it's impossible with a camera. Because of this, drivers who contest their red light camera tickets may have a good chance of getting their cases dismissed. If you admit to running the red light and have no defense to present, emergency, hidden signage, blurry photographic evidence, you stopped before the camera captured you entering the intersection, etc. Paying the fine is faster and easier if you have the money to pay the fine and possible increase in insurance rates, which combined can cost over $1,000. However, spending an hour or two to contest the ticket with the court or requesting mitigation may help reduce or even eliminate the penalty, keep points off your record, and prevent your insurance rates from going up, particularly if you have a good driving history or special circumstances. If you're unsure how to proceed, read on and we can help you decide whether to take your shot or just let the government win, cop to the violation, and pay the fine. This book applies each of the following quotes in their relevance to the question of whether you should challenge your red light ticket. Spoiler, you should take your best shot if you have a leg to stand on. Thanks for listening. Thomas Paine. There is nothing wrong with a traffic law which says you have to stop for a red light, but when there is an emergency, the fire truck or the ambulance goes right through those red lights at top speed. Checker Martin Luther King. No one expects the Spanish Inquisition. Monty Python. Who was that masked man? Tonto and the Lone Ranger. Here's to you, Fuzzy Wuzzy. Rudyard Kipling. It's technical. Bill Murray. I use the rules to frustrate the law. F. Lee Bailey. Justice without mercy is cruelty. Thomas Aquinas. If not equally matched, split and reevaluate. Bud Fox. Chapter 1, Understanding Red Light Laws. Before you can effectively contest a red light ticket, it's essential to understand the laws that govern red light violations. These laws vary by state and sometimes even by city, but the underlying principles are similar across the United States. This chapter will explain what constitutes a red light violation, the differences between officer-issued and camera-issued tickets, and key legal concepts that will be important throughout your case. A red light violation generally occurs when a driver enters an intersection after the traffic signal has turned red. However, the precise legal definition can differ based on local statutes. Drivers must stop at the marked stop line or, if none, before entering the crosswalk or intersection. In most states, turning right on red is permitted after a complete stop, unless posted otherwise. Some states allow left turns on red from a one-way street onto another one-way street, but this is less common. Many drivers believe there is a grace period after the light turns red. In actuality, most jurisdictions consider any entry into the intersection after the light turns red to be a violation, regardless of how brief the delay. The yellow light is a warning that the signal is about to turn red. Entering the intersection during a yellow is legal, but if the light turns red before you cross the stop line, you may be cited. Red light tickets are issued in two main ways: by a law enforcement officer or by an automated red light camera system. Officer-issued tickets are when a police officer observes the alleged violation and pulls you over to issue a citation. The officer's vantage point, memory, and ability to observe all relevant facts are subject to challenge in court. Camera-issued tickets, on the other hand, are when automated cameras take photos or videos of vehicles that enter an intersection after the light turns red. The ticket is mailed to the registered owner, who may or may not have been the driver. Camera maintenance, calibration, image clarity, and legal requirements for notice are all potential defenses to a red light camera ticket. In many jurisdictions, the ticket is sent to the vehicle's registered owner, who may not have been driving at the time. Red light laws are governed primarily by state vehicle codes, but cities and counties often have their own ordinances and enforcement practices. In California, for example, Vehicle Code Section 21453 requires a complete stop at a red signal and allows right turns on red unless posted otherwise. In New York, Vehicle and Traffic Law Section 1111 governs red light violations and similarly allows right turns on red after a stop unless prohibited by signage. In Texas, Transportation Code Section 544.007 covers traffic signals, with similar rules for right turns. Some cities have stricter rules or additional signage. Always check local ordinances, especially if you received a camera ticket. For a red light ticket to be enforceable, certain legal requirements must be met. The ticket must be delivered within a specific time frame, often 15 days for camera tickets. The ticket must clearly identify the vehicle and, where required, the driver. There must be sufficient evidence, officer testimony or clear camera footage, to prove the violation. Understanding the potential impact of a red light ticket is important as you decide how to proceed. Red light tickets can cost from $50 to over $500, depending on the state and whether it's a first offense. Many states add points to your driving record, which can lead to higher insurance premiums and possible license suspension. Some insurers increase rates after a red light violation, especially if points are assessed. In some jurisdictions, unpaid tickets can result in a hold on your vehicle registration or other penalties. Knowing the specific red light laws in your state and locality is the first step in mounting an effective defense. It allows you to identify possible legal or procedural errors in your ticket, argue your case more persuasively in court, and understand your rights and obligations at every stage. Red light laws are designed to promote safety, but are not infallible. Mistakes happen, both by drivers and by the systems used to enforce these laws. By understanding the legal framework, you are better equipped to challenge a ticket and protect your driving record. Key takeaways. Red light laws vary by state and city. Always check local rules. Tickets can be issued by officers or cameras, each with unique defense strategies. Legal requirements for a valid ticket include proper notice, identification, and evidence. The consequences of a red light ticket can be significant, making it worthwhile to understand your rights and options. In the next chapter, we'll explore the ticketing process in detail, including how tickets are issued, what information they must contain, and your rights as a driver facing a red light citation. Chapter 2. The Ticketing Process. Understanding the process by which a red light ticket is issued, processed, and adjudicated is essential for anyone seeking to contest a citation. This chapter explains each step, from the moment of the alleged violation to your options for response, and highlights your rights and obligations throughout. If a police officer observes what they believe to be a red light violation, they may initiate a traffic stop. The officer will request your license, registration, and insurance, and then issue a citation on the spot. The ticket will include the date, time, and location of the alleged violation, your vehicle and personal information, and instructions for responding. Many intersections, on the other hand, are equipped with red light cameras that automatically photograph vehicles entering the intersection after the light turns red. The system captures images and/or video, which are reviewed by law enforcement or a third-party contractor. If a violation is confirmed, a ticket is mailed to the registered owner of the vehicle. Most jurisdictions require that the notice be mailed within a specific time frame, often 15 days from the date of the alleged violation. A red light ticket, whether issued by an officer or a camera, typically includes date, time, and location of the alleged violation, vehicle information, make, model, license plate, photographic evidence for camera tickets, instructions for responding, pay, contest, request hearing, deadline for response, fine amount, and possible additional fees. If stopped by an officer, you receive the ticket immediately. Your signature may be requested. This is not an admission of guilt, but an acknowledgement of receipt. For camera tickets, the citation is mailed to the address on file with the DMV. If you have moved and not updated your address, you may not receive timely notice, which can be a defense in some jurisdictions. You have the right to contest a red light ticket in court. This may involve appearing in person, submitting a written declaration, or requesting a trial by mail, where available. You are entitled to review the evidence against you. For camera tickets, this includes photos, video, and maintenance calibration records. You can request this evidence through a process called discovery. Many states allow drivers to contest red light camera tickets and other traffic infractions in writing, commonly known as a trial by written declaration or written statement. This process lets you submit your defense and evidence by mail or online without appearing in court. The following states are confirmed to allow contesting red light tickets by written declaration or written statement: California, Florida, Hawaii, Indiana, Louisiana, Nebraska, Ohio, only in certain courts, Oregon, Washington, Wyoming, only in certain courts. The way the process works is you fill out a court-provided form or write a statement explaining your case and attach any supporting evidence, photos, witness statements, etc. The officer or agency submits their own written statement. A judge reviews both sides and issues a decision by mail. If you win or the fine is reduced, your payment, if required up front, may be refunded. Some other states may allow written statements for specific circumstances, such as submitting an affidavit of non-responsibility if you were not the driver, but not a full trial by written declaration for contesting the merits of the ticket. Always check the instructions on your citation or your local court's website to confirm eligibility and procedures for your specific case. In any event, you must respond to the ticket by the deadline indicated, typically within 15 to 30 days. Failure to respond can result in additional penalties, including increased fines, a hold on your vehicle registration, or even a warrant in some cases. Date of infraction: the alleged violation occurs. Ticket issued: officer issues on the spot, or camera system generates a ticket and mails it. Notice period: you receive the ticket immediately or by mail. Response deadline: usually 15 to 30 days from issuance or mailing. Hearing or trial: if you contest, a hearing is scheduled, often several weeks to months later. Judgment: the court or hearing officer decides the outcome. You have several options for responding to the ticket. You can simply pay the fine, which is an admission of guilt. However, the violation may appear on your driving record, and points may be assessed depending on your state. You may also plead not guilty and request a hearing. This allows you to present evidence and challenge the prosecution's case. Alternatively, some jurisdictions allow you to attend traffic school in lieu of points on your record, even if you pay the fine. Similarly, in some areas, you can request a mitigation hearing to explain circumstances and ask for reduced penalties, even if you admit the violation. Here are some special considerations for camera tickets. Registered owner liability. The ticket is sent to the registered owner, who may not have been driving. Some states allow owners to submit an affidavit of non-responsibility. Service requirements. If the ticket is not properly served, e.g., mailed late or to the wrong address, you may have grounds for dismissal. Right to confrontation. In some jurisdictions, you can challenge the admissibility of camera evidence if the prosecution does not present a live witness who can authenticate the evidence. Whatever you do not ignore a red light ticket and do not lie to the court. Failing to respond can result in increased fines and late fees, driver's license suspension, vehicle registration hold, referral to collections, and even potential issuance of a bench warrant. Rare for infractions but possible in some states. To summarize, the ticketing process begins with either a traffic stop or automated camera capture. You have rights to contest, review evidence, and receive proper notice. Deadlines are strict. Missing them can have serious consequences. Understanding each step in the process is key to mounting an effective defense. Chapter 3. Common defenses to red light tickets. So what are some of the common defenses to red light tickets? Well, here are some technical, procedural, and substantive arguments you can use in court. Receiving a red light ticket can be stressful, but it's important to remember that you have the right to contest the charge. Many drivers are surprised to learn that red light tickets, especially those issued by cameras, can be successfully challenged. This chapter explores the most effective defenses, providing practical examples and legal principles to help you build your case. Technical defenses challenge the accuracy or reliability of the equipment or conditions at the time of the alleged violation. Red light cameras and sensors must be properly maintained and calibrated. If you suspect a malfunction, you can request maintenance and calibration records through discovery. Courts have dismissed tickets when the prosecution could not prove the camera was functioning properly. For example, in People v. Khaled, 186 California Appellate Reports 4th Series Supplement 1, 2010, the court found that the prosecution must provide evidence of proper camera maintenance and calibration. If records are missing or show lapses, you may have grounds for dismissal. Traffic signals and signs must be visible and understandable. If a sign was blocked by a tree, construction, or another vehicle, take photographs and present them as evidence. For example, if a "no turn on red" sign was obscured by overgrown branches, you can argue that you could not reasonably be expected to obey an invisible sign. The duration of the yellow light is regulated by law or engineering standards. If the yellow interval is too short, it increases the likelihood of unintentional violations. You can use this defense by requesting the intersection's yellow light timing records. Compare them to state or federal standards, such as those in the Manual on Uniform Traffic Control Devices. If the yellow was too short, argue that the signal timing was unsafe and contributed to the violation. Procedural defenses focus on whether the authorities followed the correct legal process. Most states require that camera tickets be mailed within a specific time frame, often 15 days. If you received your ticket late or it was sent to the wrong address, you may have grounds for dismissal. For example, if your state's law requires notice within 15 days and you received it after 25 days, present the envelope and citation as evidence. Tickets must include certain details such as the date, time, location, and vehicle information. If any required information is missing or incorrect, the ticket may be invalid. For example, if the ticket lists the wrong intersection or your license plate number is incorrect, bring this to the court's attention. The prosecution must prove you committed the violation according to the applicable burden of proof, e.g., by a preponderance of the evidence in most jurisdictions, or by clear and convincing evidence, or beyond a reasonable doubt in others. For camera tickets, this means clear photos or videos showing your vehicle, and in some states, the driver. For example, if the photo is blurry, does not show your license plate, or does not clearly show the violation, argue that the evidence is insufficient. Substantive defenses address the circumstances of the alleged violation. If you ran the red light to avoid an accident or because of a medical emergency, you may be excused. Document the situation with witness statements, police reports, or medical records if possible. For example, if you entered the intersection to avoid being rear-ended or to rush someone to the hospital, explain the situation and provide supporting documentation. For camera tickets, the registered owner is often cited, but they may not have been driving. Some states require the prosecution to prove who was driving. Others allow owners to submit an affidavit of non-responsibility. For example, if you were out of town and someone else was driving your car, you should provide evidence such as travel records or a signed statement from the actual driver. In most states, right turns on red are legal after a complete stop unless posted otherwise. If you were cited for turning right on red, check for signage prohibiting it. If there was no sign, argue that your action was lawful. If your ticket was issued by an officer, you can challenge their account. For example, you could argue that the officer could not clearly see the intersection or your vehicle. Or you could question the officer's ability to recall details, especially if the intersection is busy or visibility was poor. You may wish to cross-examine the officer by asking about their location, what they saw, and whether anything may have obstructed their view. Camera tickets rely on technology, which is not infallible. Issues with camera tickets include image quality. Photos or video must clearly show your vehicle and the violation. Chain of custody. The prosecution must show that the evidence was not tampered with. Authentication. In some states, a live witness must testify about the camera's operation and maintenance. Here are some sample statements you can adapt for your defense. The yellow light at this intersection was only 2.5 seconds, below the state minimum of 3.0 seconds. This created an unsafe situation. The no turn on red sign was completely obscured by tree branches, as shown in these photographs. I received the citation 22 days after the alleged violation, but state law requires notice within 15 days. I was not the driver at the time of the violation. I have attached an affidavit from the actual driver and evidence of my travel. In summary, red light tickets are not automatic convictions. By understanding and applying technical, procedural, and substantive defenses, you can raise reasonable doubt and increase your chances of dismissal or reduction. Always gather evidence, research your local laws, and present your case clearly and respectfully. Chapter 4. Gathering and organizing your evidence. A strong defense against a red light ticket relies on evidence, facts and documentation that support your version of events or reveal flaws in the prosecution's case. Whether your ticket was issued by an officer or a camera, gathering the right evidence can make the difference between dismissal and conviction. This chapter will guide you step by step through the process of collecting, organizing, and presenting evidence to maximize your chances of success in court. Evidence comes in many forms. The most common types relevant to red light tickets include photographs and videos, official records and documents, witness statements, physical evidence, expert testimony. Each type can be used to support technical, procedural, or substantive defenses described in the previous chapter. It is important you know that you have the right to request discovery. So what is discovery? Discovery is the legal process by which you request and obtain evidence from the prosecution, usually the city or police department. For red light camera tickets, discovery is especially important because much of the evidence is in the hands of the authorities. So how do you request discovery? First, check the local rules. Procedures vary by jurisdiction. Some courts have forms, others require a written request. Regardless of the procedure, you can ask for photographs and videos of the alleged violation, maintenance and calibration records for the camera or traffic signal, the issuing officer's notes or reports, if officer issued or even if camera issued, and a copy of the citation and all correspondence. For example, a simple discovery request letter as follows will likely suffice. I respectfully request copies of all evidence related to citation number XXXX, including photographs, video footage, maintenance and calibration records, and any officer notes or reports. You will want to submit your discovery request as soon as possible. Some jurisdictions require requests to be made within a certain number of days before your hearing. Once you receive the prosecution's evidence, review it carefully and answer the following questions. Are the photographs clear? Can you see the license plate and the signal? Does the video show the violation clearly? Is the date, time, and location correct? Are there any gaps or inconsistencies? For example, does the photo show your car already in the intersection when the light turns red? Next, gather your own evidence. Visit the intersection and take photos and videos from the driver's perspective and other relevant angles. Photograph all traffic signs, e.g., no turn on red, and note if any are blocked or missing. Show if the traffic signal was obscured by trees, poles, or other objects. Document weather, construction, or anything else that may have affected your ability to see or respond to the signal. Draw a diagram and sketch the intersection, marking the location of signals, signs, your vehicle, and other relevant details. You can use online maps to print or annotate satellite images or street views from services like Google Maps to support your diagram. Put together witness statements. If someone was with you, ask them to write a statement describing what they saw. If anyone else, e.g. bystanders, witnessed the incident, their statement can be valuable. All statements should be signed under penalty of perjury, be dated, and include contact information. If your car has a dash cam, GPS, or telematics data, retrieve footage or logs for the time of the alleged violation. If you claim you were not driving, e.g. your car was loaned out, provide supporting documents such AIS, travel records, or affidavits. Obtain official records for the signal timing and maintenance by a discovery request to the city or county. Ask for the yellow light timing records and maintenance logs for the signal or camera. Be sure to cite your right to this information as part of your defense. See Chapter 7 for statutes and case law. If you believe the yellow interval was too short, request the intersection's traffic engineering report and compare the actual timing to state or federal standards. Create a binder or folder to organize your evidence. Keep all documents, photos, and statements organized. Label everything by clearly marking each piece of evidence, e.g., Exhibit A, photo of intersection. Write a short summary of your evidence to present to the judge. If you go to court to present your evidence, bring originals and copies. Courts may keep copies of your evidence, so bring extras. Be clear and concise when you explain how each piece of evidence supports your defense. When speaking, refer to your evidence by label, e.g. as shown in Exhibit B. Anticipate questions and be ready to explain how and when you gathered your evidence. If your defense relies on technical issues, e.g. camera malfunction, improper signal timing, consider consulting a traffic engineer or technology expert. Experts can write a report or, in rare cases, testify in person. Here is a sample checklist of evidence to consider. Copy of the citation, photographs of the intersection and signage, video footage from the city or your dash cam, maintenance/calibration records, yellow light timing data, witness statements, diagrams or maps, receipts, affidavits, travel records for identity, expert report if applicable. Gathering and organizing evidence is a crucial step in contesting a red light ticket. The more thorough and well-presented your evidence, the stronger your defense will be. Always act quickly, follow local procedures, and keep your documentary evidence organized. Chapter 5. Preparing your case. Now it's time to prepare your case, organize your arguments, and get ready for your day in court. Once you've gathered your evidence, the next critical step is organizing it into a compelling case. Proper preparation can make the difference between success and failure in traffic court. This chapter will guide you through the process of building a persuasive defense, organizing your materials, and developing a clear strategy for your hearing. Before preparing your case, it's important to understand how traffic court works. In some jurisdictions, you'll first attend an arraignment where you enter your plea, followed by a trial if you plead not guilty. The prosecution has the burden of proving you committed the violation. In most jurisdictions, this means the local government must prove by a preponderance of the evidence that you committed a traffic infraction in violation of the applicable law. Preponderance of the evidence simply means it is more likely than not, more than a 50-50 chance, that you committed the offense, i.e., ran the red light. The preponderance of evidence standard is much lower than the clear and convincing, think 70% likely, or beyond a reasonable doubt, think 90% likely, standards used in a select few jurisdictions for red light citations. The beyond a reasonable doubt standard is the applicable burden of proof for all criminal cases, but in most states and local jurisdictions, red light tickets are classified as civil violations, infractions, not criminal offenses, and do not result in a criminal record or jail time. The penalty is a fine, and the process is administrative, not criminal. Red light tickets can, however, count as points on your driver's license and affect your insurance rates in most U.S. states, but there are important distinctions depending on the type of ticket and state law. For officer-issued red light tickets, where a police officer stops you, these are almost always treated as moving violations. In nearly every state, this means points are added to your driving record. Your insurance rates may increase, typically $150 to $300 per year on average, and the violation remains on your record for several years, often 3+ years. Examples of states where this applies include California, New York, Texas, Florida, Illinois, Georgia, Pennsylvania, New Jersey, and Arizona, as well as most other states. Red light camera tickets, on the other hand, are a special case, and most states and cities treat red light camera tickets differently. In New York, California, and most other states, red light camera tickets are not considered moving violations, so they typically do not add points to your license. However, officer-issued tickets in these same states do add points and do raise insurance rates. As of this writing, the national standard is no points for red light camera tickets, and nearly all states treat camera tickets as non-moving civil offenses. However, if a state were to classify a camera ticket as a moving violation, it could assign points. Some states have special rules for camera tickets prohibit insurance companies from using red light camera tickets to set rates, and typically points are not assigned for these tickets. It is up to each state to decide whether camera violations are reported to the Department of Motor Vehicles, DMV. If not reported, typically no points are assessed, and insurance companies typically do not receive notice, leaving rates unaffected. While some states expressly prohibit insurance companies from using red light camera tickets to set rates, e.g. California, Florida, and Texas, most do not, and if your insurer discovers a red light camera ticket, they may not be prohibited from raising rates. In addition, red light camera tickets can indirectly affect your insurance if they lead to license suspension, vehicle registration cancellation, or collections. In these cases, the resulting suspension or negative credit event, not the ticket itself, can impact your rates. In summary, always check your local jurisdiction for the most current rules, but the national standard for the United States is no points for red light camera tickets. That said, in some states, there are exceptions for local jurisdictions that treat camera tickets as moving violations, rare, and may still add points. If a state does not ban insurance companies from increasing and affecting insurance, rates could be directly or indirectly affected. Points and insurance summary by state. In California, New York, Florida, Illinois, Pennsylvania, Georgia, Arizona, and New Jersey, officer-issued tickets give rise to points and insurance impacts, and camera tickets do not. In Texas and most other states, officer-issued tickets give rise to points and insurance impacts, and in most cities, camera tickets do not. But there are some exceptions, city by city, so be sure to check. Key takeaways. Officer-issued red light tickets, where a police officer stops you, are still considered traffic infractions, which are also non-criminal, but they do carry points and can increase insurance rates in nearly all states. However, in most states, only certain serious traffic violations, such as reckless driving, DUI, or fleeing from police, are treated as criminal offenses. Red light camera tickets usually do not add points or affect insurance when classified as a civil violation. Always check your specific state and local laws or consult your insurance provider for details. Bottom line, if you receive an officer-issued red light ticket in almost any state, expect points on your license and a likely insurance rate increase. Camera tickets are generally less severe and often do not affect your record or insurance. Civil versus criminal summary by type of ticket. Is it civil or criminal? Are points assessed? Is there an insurance impact? Is it a fine-only infraction? Camera-issued ticket. Civil, points unlikely. Insurance impact. Unlikely, fine only. Officer-issued ticket. Civil, points yes. Insurance impact yes, fine only. Criminal traffic offense. It's a crime only when associated with another criminal offense, e.g., reckless driving, DUI, but not for a standard red light violation. Points yes, insurance impact yes, fines and possibly more. Red light tickets for civil violations, especially camera tickets, are not criminal. As such, they are handled as civil infractions and carry only a monetary penalty unless accompanied by more serious charges. Like most traffic infractions, red light tickets are typically heard by a judge or magistrate, not a jury. In some jurisdictions, the officer who issued the ticket may not be required to attend. A representative from the police department may present the ticket or report as evidence. Now it is time to organizing your defense and choose your defense strategy. Based on the evidence you've gathered, select the strongest defense approach. Technical defenses focus on equipment malfunction, improper signage, or short yellow light timing. Procedural defenses challenge the notice, ticket accuracy, or procedural errors. Substantive defenses argue necessity, emergency, or mistaken identity. Develop a clear, logical case outline and structure for your presentation, including the following. Introduction, brief statement of why you're contesting the ticket. Facts, timeline of events from your perspective. Legal argument, specific laws or precedents supporting your position. Evidence presentation, how each piece of evidence supports your defense. Conclusion, summary of why the ticket should be dismissed. You should prepare a written statement whether appearing in person or by written statement only. Many courts allow you to submit a written statement instead of appearing in person. Make your format clear, concise, and respectful. Your content should include the facts, legal arguments, and reference to the evidence. The written statement must be submitted and received by the court before the time limitations imposed by local law, e.g., at least 7 days before your scheduled hearing in many jurisdictions. If appearing in person or via Zoom, practice and rehearse your statement to ensure it's clear and within time limits. Your tone should always remain respectful and factual. Avoid emotional arguments. Be organized and use notes to keep your presentation on track. If the officer appears, you'll have the opportunity to ask questions, so you should prepare to cross-examine. Prepare and write down specific questions focusing on weaknesses in their case. Areas to focus on include the officer's vantage point, visibility conditions, or memory of specific details. Avoid using an argumentative tone and stick to asking factual questions rather than making accusations. Organize your evidence by creating an evidence packet. Prepare copies of all evidence for the judge. Keep originals and an extra set of copies for yourself. Label each item, Exhibit A, B, C, etc., and create a table of contents. Think about the order of presentation for your evidence and arrange it to tell a logical story. Include the citation and official documents such as the ticket itself and any related notices. Add photographs and diagrams as visual evidence of the intersection. Don't forget to include technical records if you obtain them in discovery addressing signal timing, maintenance logs, etc. And finally, be sure to include witness statements setting forth written testimony supporting your version of events, especially your own. Think about how to prepare your legal arguments. Research applicable laws, including A, the state vehicle codes and specific sections related to your violation. B, local ordinances, being sure to check for specific local rules that may apply. And finally, C, case law, looking for similar cases that were dismissed. See Chapter 7. Format your legal references properly. For example, according to Vehicle Code Section X, a right turn on red is permitted after a complete stop unless otherwise posted. Or, in the case of Smith versus City of Springfield, the court found that yellow light timing below 3.5 seconds was inadequate. For red light camera tickets, prepare to address the specific issues. For example, if you weren't driving, be sure to submit a declaration of non-responsibility and prepare an affidavit stating who was. Challenge the authentication of the evidence and question how it was verified and maintained. And finally, research your state's specific technical requirements for camera tickets and point out to the court each requirement that was not met in your case, e.g., no stop line visible in the camera photo, no signage, etc. For tickets issued by an officer, make observation challenges and prepare questions about the officer's vantage point. Point out and emphasize any conflicting testimony and note any inconsistencies between the ticket and officer's statements. Raise any factors affecting visibility by documenting the weather, obstructions, or other factors affecting the officer's ability to visually observe the scene. Prepare yourself for the possible different outcomes. If you win, be prepared to request written confirmation of dismissal and confirm and verify with the court verbally for the court reporting system that no points will be added to your record. If you lose, consider asking the court about your options, including traffic school, if available, payment plans, and the appeal process, if grounds exist. Final preparation checklist. Defense strategy selected, case outline completed, statement prepared and practiced, cross-examination questions written, evidence organized and labeled, legal arguments researched and documented, multiple copies of all materials, directions to courthouse and parking information, court date and time confirmed. In summary, thorough preparation is essential to successfully contesting a red light ticket. By organizing your evidence, crafting clear arguments, and understanding the court process, you'll present your case confidently and effectively. Remember that judges appreciate well-prepared, respectful presentations that focus on facts and law rather than emotions or excuses. Chapter 6, Court Procedures. Understanding what happens in court is critical to successfully contesting a red light ticket. In this chapter, we will explore court procedures in detail, including what to expect during your hearing, how to present your case, and proper courtroom etiquette using Washington state procedures and laws as an example jurisdiction. Here we will cover the types of hearings available, what to expect before and during your hearing, how to present your case, and how the judge makes the decision. When you receive a red light ticket, you typically have three main options. 1. You can pay the fine by admitting the violation and closing the case. You can request a mitigation hearing where you admit the violation, but ask the judge to reduce the penalty due to circumstances. You can request a hearing to contest and challenge the violation and ask the court to dismiss the ticket. Only a contested hearing gives you a chance to have the ticket dismissed outright. Now it is time to schedule and prepare for your hearing. To request a hearing, you typically just check the box on your ticket for a contested hearing and return it by the deadline, usually within 30 days. The court will schedule your hearing, e.g., in Washington within 60 days from your request. Next, gather your evidence and organize your documents, photos, and witness statements as described above in Chapter 5. If you want witnesses to appear, you may wish to request a subpoena from the court if there is any chance they won't voluntarily show up. You can typically choose from several hearing formats, including an in-person hearing, where you appear before a judge at the courthouse. You may also be able to appear remotely for the hearing via Zoom or another video platform. Many jurisdictions allow you to contest a red light ticket by a written statement, submitting your defense in writing, whereafter the judge will decide the case without you present. Check to see if your local jurisdiction has a form for contesting by written statement, declaration, or affidavit. Your sworn written statement under penalty of perjury must be received within the time limitations of the local jurisdiction, e.g., at least 7 days before your scheduled hearing. Before the hearing, be sure to arrive and check in early or log in on time if the hearing is being held remotely. Prosecutors may offer reductions or dismissals before the hearing starts. Take this opportunity to discuss your case if you believe there is a major flaw in the ticket. At the opening of the hearing, the judge will call your case and explain the process. Remember, the city or state prosecution must prove by a preponderance of the evidence that you committed the violation. For camera tickets, a representative may show up to present the evidence, photos, video, records. For officer-issued tickets, the officer may show up and testify. You can cross-examine and question the officer or city representative about their observations, the accuracy of the evidence, and any procedural errors. You then present your evidence and arguments. You should refer to your exhibits and will be allowed to call witnesses, if any. The judge may ask you or the prosecution questions for clarification. If you submitted a written statement, the judge will review it along with the evidence you submitted as well as the prosecution's evidence. The court will then make its decision and mail it to you after the hearing date. So how does the judge decide? The judge will weigh the evidence and testimony by a standard that is nearly always preponderance of the evidence to determine if it is more likely than not, more than a 50-50 chance, that you committed the violation. If the prosecution does not meet this burden, the judge must dismiss the ticket. After the hearing, the judge issues the decision, typically by announcing it in open court, or mails it to you if you appeared remotely or submitted a written statement. If the ticket is dismissed, there is no fine and nothing is added to your record. If the ticket is upheld, you will need to pay the fine or consider further options: appeal, payment plan, or traffic school if available. Generally, there is no insurance impact. There are several special considerations for camera tickets you should always remember and be aware of. In most states, e.g. Washington, camera tickets are processed like parking tickets and do not appear on your driving record. If you were not the driver, you should submit a declaration and affidavit under penalty of perjury stating so. In addition, remember you have a right to review the video evidence, often online as is the case in the state of Washington, before your hearing. Here are a few practical tips for court. Be respectful and address the judge as Your Honor. Be organized and have all your documents and evidence ready. Be concise and stick to the facts in your strongest arguments. Dress appropriately. Dressy casual will usually suffice, or coat and tie for men. And present yourself professionally, even for remote hearings. To summarize, court procedures for red light tickets are designed to be accessible and expeditious, but preparation is key. Request a contested hearing if you want to fight the ticket. Organize your evidence and present your case clearly. Whether appearing in person, remotely, or by written statement, understanding the process will help you maximize your chances of success. By doing so, you could save thousands of dollars over the years to come. Chapter 7. Using Legal Precedents in Authorities. This chapter focuses on the practical application of legal precedents and authorities of the law and how you can use them to support your arguments in court. The discussion below uses Washington state procedures and laws as an example jurisdiction, but you can just Google something like red light ticket laws in New York or something similar for additional information. A strong legal defense is built on more than just facts. You don't have to be a lawyer to successfully defend yourself, but a solid defense will require some understanding of the basic legal principles and authorities, i.e., laws, statutes, ordinances, and court decisions that govern red light tickets. In most jurisdictions, both state law and local ordinances define how red light camera tickets are issued, contested, and enforced, e.g., Title 46 of the Revised Code of Washington, RCW. This chapter explains some of the most important legal principles, where to find them, how to use them in your defense, and what sorts of precedents may help you win your case. In most jurisdictions, there are a few key statutes that govern red light tickets: CEEG RCW 46.6(1.050), obedience to traffic control devices. Statutes requiring obedience to traffic control devices and signals, including signs, is the foundation for red light violations in most states. These statutes require drivers to obey all official traffic control devices, including red lights, unless otherwise directed by a police officer. Typically, such a statute reads something like, "Every driver of a vehicle shall obey the instructions of any official traffic control device applicable thereto." For example, New York Vehicle and Traffic Law, Section 1110, is New York's equivalent to Washington's RCW 46.61.05 statute, requiring obedience to all traffic control devices. Violating such a statute is the basis for most red light tickets, whether issued by an officer or a camera. In addition, states which allow camera red light tickets have specific state laws designed to enforce them. CEG 7.2.2, RCW 46.63.075. Safety camera infractions, presumption. These statutes typically create a prima facie presumption that the registered owner of the vehicle was the driver at the time of the violation. For example, Washington law states, proof that the particular vehicle described in the notice of traffic infraction was in violation, together with proof that the person named in the notice was at the time of the violation the registered owner, constitutes in evidence a prima facie presumption that the registered owner was the person in control of the vehicle. If you were not the driver, you may rebut this presumption by submitting a sworn statement, affidavit or declaration, or testify under oath to rebut this presumption. But see also New York Vehicle and Traffic Law, Section 1111A, which imposes liability on the vehicle owner for red light camera violations, regardless of who was driving at the time. So in Washington, if you are not driving the car, you are not liable for the ticket. In New York, however, the registered owner of the vehicle is presumed liable for a red light camera violation, regardless of who was driving, unless the owner can prove the vehicle was being used without consent, e.g., it was stolen. Most state statutes authorize cities and counties to use automated cameras for traffic enforcement. These statutes typically also require notice to the public and posting of signs to warn drivers that cameras are in use. Timely notice is also required, CEG RCW 46.63.170, which requires tickets to be mailed within 14 days of the violation. The law in every state gives you the right to contest or pay or mitigate the ticket and will outline the specific procedures for hearings to do so. CEG RCW 46.63140, Disposition of Infractions. One of the most important legal principles for you to be familiar with is the applicable standard of proof. For most traffic infractions, the standard of proof is by a preponderance of the evidence, which means the government must prove it is more likely than not that you committed the violation. Camera tickets are typically non-criminal in nature. In Washington, for example, red light camera tickets are processed like parking tickets. They do not go on your driving record and typically do not affect your insurance rates. In some jurisdictions, there is no requirement to identify the actual driver. Just like the privilege against self-incrimination is a constitutional right, which allows individuals to refuse to answer questions or provide information that could implicate them, most state red light laws do not require you to name or identify the actual driver if you were not driving. You only need to state under oath that you were not the driver. For the court to consider any testimony, photo, or video as evidence, it must be admissible. For camera tickets, a law enforcement officer must review the evidence and certify the infraction or violation before a ticket is issued. If the ticket is not properly certified, it is not admissible. Remember, you have the right to review all evidence against you, including photos, videos, records, and even in some circumstances, the camera itself. Wherever possible, you should use legal authorities to support your defense by citing to statutes and case law precedents. When presenting your case, clearly reference the law or precedent that supports your argument. For example, under RCW 46.63.075, the presumption that I was the driver can be rebutted by my sworn statement that I was not operating the vehicle at the time. RCW 46.63170 requires that notice of a camera ticket be mailed within 14 days. My ticket was mailed after this period and is therefore invalid. Don't be shy about challenging the sufficiency of the evidence. If the ticket lacks clear photos or video, or if the officer's certificate is missing, cite the requirement for proper evidence and the lack of the required chain of custody. If there is a lack of proper notice, i.e., if the city failed to post adequate signage or mailed the ticket late, cite to the relevant sections of the law if you can. In some jurisdictions, it may be effective to rebut the presumption of ownership by submitting an affidavit under penalty of perjury stating you were not the driver. In most, if not all jurisdictions, you are not required to identify the actual driver. Here are a few samples of legal arguments for you to consider. Argument 1, late notice. The law requires that a notice of infraction be mailed within 14 days of the violation. The ticket in this case was mailed 20 days after the alleged violation, making it invalid. CR CW 46.63170. Argument 2, not the driver. The law creates a presumption that the registered owner was the driver, but I submit my sworn statement that I was not operating the vehicle at the time. Therefore, the presumption is rebutted, and the prosecution has not met its burden of proof. CRCW 46.6 3075. Argument 3, inadequate signage. The law requires visible signage warning of camera enforcement. There was no such sign at the intersection, as shown in my attached photographs. The ticket should be dismissed for lack of proper notice. Argument 4, insufficient evidence. The photographs provided do not clearly show my vehicle entering the intersection after the light turned red. The city has not met its burden of proof. While most red light camera defenses rely on statutes, you may also cite case law if relevant. For example, if an appellate court, preferably in your state, but also other states as well, has ruled on the admissibility of camera evidence or the requirements for signage, cite that decision to strengthen your argument. When should you seek legal help? Most red light camera tickets are minor infractions and may not warrant hiring an attorney due to cost. However, if your case is complex, involves multiple violations, or has significant financial or legal consequences, consider consulting a traffic attorney. You can find out who handles traffic tickets by calling your state or county local bar associated referral service. Summary of Washington state examples of key legal authorities by authority subject and how to use in defense. RCW 46.6105. Obedience to signals is the basis for violation. Check for exceptions to enforceability. RCW 46.63075. Presumption of owner as driver. Submit affidavit to rebut presumption. RCW 46.63170. Camera enforcement and notice. Challenge if signs missing or notice is late. RCW 46.63140. Hearing procedures. Know your rights to contest or mitigate. To summarize, knowing the statutes and legal principles behind red light tickets empowers you to make clear, effective arguments in court. Always organize your defense around the relevant laws, cite them directly, and use your evidence to show that the city or state has failed to meet its burden. Chapter 8, Drafting Legal Papers. In this chapter, you'll learn how to draft a legal memorandum and present your points and authorities in a persuasive format for the court. A legal memorandum, often called a memorandum of points and authorities, is a structured document that presents your legal arguments, supporting statutes, and case law to the court. A memorandum used to successfully challenge a camera-issued ticket is set forth in Appendix C. In addition, you can obtain forms and templates online or from the court. See Appendices A and B. While not always required for traffic infractions, submitting a clear, concise memorandum can demonstrate your preparation and help the judge quickly understand your defense. This chapter will teach you how to draft an effective memorandum with sample arguments and practical tips. So what is a legal memorandum of points and authorities? A legal memorandum is a written argument that states the issues before the court, summarizes the relevant facts, presents legal arguments supported by statutes and case law, requests a specific outcome, such as dismissal of the ticket. Memoranda are especially useful for complex defenses, written hearings, or when you want to ensure your legal points are thoroughly considered. A strong legal memorandum typically is structured to include the following sections: caption, case information; introduction, statement of facts; legal argument, points and authorities; conclusion, signature and date; exhibits, if any. For your introduction, briefly state your request and the basis for it. For example, defendant respectfully submits this memorandum in support of the motion to dismiss the red light camera infraction issued on date, on the grounds that the city has failed to comply with statutory requirements and has not met its burden of proof. For your statement of facts, simply summarize the key facts relevant to your defense. For example, on June 1, 2025, defendant received a notice of infraction by mail alleging a red light violation at the intersection of Main Street and Fifth Avenue. The notice was postmarked June 20, 2025, days after the alleged violation. Defendant was not the driver at the time of the incident. Your legal argument, your points and authorities, is where you organize your arguments by issue, citing statutes and case law. For example, if the notice was late, the ticket may be invalidated. You points and authorities could simply say, the law requires that a notice of infraction be mailed within a certain amount of time after the date of the violation. ARCW 46.631701G states, a notice of infraction must be mailed to the registered owner of the vehicle within 14 days of the violation. Here, the notice was mailed days after the alleged violation. The city's failure to comply with the statutory deadline renders the notice invalid. If you seek to rebut the presumption that you were driving the vehicle, you could simply say, the law creates a presumption that the registered owner was the driver, but this can be rebutted by sworn statement. RCW 46.63075. Defendant submits herewith an affidavit as Exhibit A, affirming that he/she was not driving the vehicle at the time. If you wish to argue that the prosecution's evidence is insufficient, you could include a section saying, the prosecution bears the burden of proving the violation by a preponderance of the evidence. The photographs provided do not clearly show the defendant's vehicle entering the intersection after the light turned red. See Exhibit B. After you have made all your arguments in defense of the ticket, write your conclusion summarizing your request for a dismissal. For example, for the foregoing reasons, defendant respectfully requests that the court dismiss the red light camera infraction. Be sure to sign and date the memorandum respectfully submitted, followed by your signature, your name, and the date of signing. Attach all referenced exhibits, affidavit, photos, records, and label them clearly. Here are some tips for submitting an effective memorandum. Be concise. Judges appreciate brevity and clarity. Use headings. Organize arguments with clear headings and subheadings. Cite authority. Always reference the relevant statute or case law. Attach evidence. Include copies of supporting documents. Proofread. Check for typos, errors, and clarity. See Appendices C and E for sample points and authorities from a memorandum used to successfully challenge a red light camera ticket in Washington. Many courts, such as in Washington, provide downloadable forms on their websites for specific requests: hearing, deferral, dismissal. Always check your local court's website for the latest forms and instructions. So how and when do you submit your memorandum? As to timing, research your local law, or call the court clerk, to find out how many days before your hearing you must submit and file your memorandum. For example, in Washington, you must submit your memorandum at least 7 days before your hearing if possible, or bring copies to your in-person hearing. File your memorandum timely with the court clerk and serve a copy on the local prosecutor, either in person or by mail if allowed. Regardless, bring or submit extras copies for the judge and opposing party to the in-person hearing, if any. A well-drafted legal memorandum can clarify your arguments and highlight weaknesses in the prosecution's case. If nothing else, it will give you a written document to use to make your oral argument to the court. By organizing your facts, citing statutes, and attaching supporting evidence, you present yourself as a credible, prepared defendant, which will greatly increasing your chances of success. Chapter 9, Negotiating with the Other Side. In this chapter, you'll learn about negotiating with prosecutors, plea options, and alternatives to fighting your ticket in court. While many drivers assume that a red light ticket must be fought in court or simply paid, there is often a third path. Negotiation. In many jurisdictions, you may have an opportunity to speak with a prosecutor or city attorney before your hearing. Through negotiation, you might secure a reduction in your fine, avoid points on your license, or even have your ticket dismissed under certain circumstances. This chapter covers when and how to negotiate, what options may be available, and how to approach these discussions for the best possible outcome. So when is negotiation possible? Some courts schedule a pre-hearing or pre-trial conference where you can meet with a prosecutor. Also, in many traffic courts, on the day of the hearing, prosecutors are available before the judge calls your case. You may be invited or asked to speak with them in the hallway or a separate room. In some jurisdictions, you can submit a written request for mitigation or reduction before your hearing date. However, not all jurisdictions allow negotiation for red light camera tickets, especially if they are treated as civil infractions, e.g., like parking tickets. However, for officer-issued tickets or in courts that treat camera tickets more formally, negotiation is often possible. So, what can be negotiated? Prosecutors may agree to reduce your fine, especially if you have a clean driving record, present mitigating circumstances, or point out a technical error. Some courts offer a deferred finding, sometimes called deferred adjudication, or probation before judgment, which allows you to keep the ticket off your record if you do not receive another violation for a specified period, often 6 to 12 months. Deferred adjudication may be subject to eligibility requirements, e.g., usually available only once every 7 years in Washington. In addition, you may be required to pay court costs and avoid further infractions. Finally, if you present compelling evidence of a procedural error, such as late notice or improper signage, the prosecutor may agree to dismiss the ticket before it reaches the judge. In some cases, a moving violation, like running a red light, can be amended, reduced, or changed to a non-moving violation, such as defective equipment, which does not add points to your record or affect your insurance. Some jurisdictions will also allow you to attend traffic school in exchange for dismissal or reduction of the violation. So how do you approach negotiation? First, be prepared to go to trial, know your case, and bring your evidence, legal arguments, and any written statements to any negotiation. Know the law and reference relevant statutes or court rules, especially if you are requesting a dismissal for procedural reasons. Be respectful, professional, and polite when you address the prosecutor or city attorney. Be concise and brief when explaining your situation and what you are seeking, e.g., dismissal, reduction, deferral. Be sure to present any mitigating circumstances, such as this is a first offense. Emphasize if you have a clean record. Explain if there was a genuine emergency, unclear signage, unusual circumstances, or other mitigating factors. Mention if you have already taken corrective actions or other steps to improve your driving, e.g., completed a defensive driving course. Finally, weigh the options and know when to accept a deal. Sometimes accepting a reduction or deferral is better than risking a full conviction, especially if your evidence is weak. And of course, get it in writing. Be sure that any agreement is documented and submitted to the court. Here are 3 sample negotiation scenarios. Scenario 1, fine reduction. I have a clean record and this is my first ticket. Would you consider reducing the fine or offering a deferral? Prosecutor, I can offer a $50 reduction or a deferred finding if you pay court costs and have no violations for the next 6 months. Scenario 2, procedural error. The ticket was mailed 20 days after the alleged violation, but state law requires notice within 14 days. Would you consider dismissing the ticket? Prosecutor, let me check the records. If that's correct, we can dismiss. Scenario 3, amendment to non-moving violation. I'm concerned about insurance points. Would you consider amending this to a non-moving violation? Prosecutor, if you plead guilty to a non-moving violation, I can amend the charge. What happens if negotiation fails? If you cannot reach a satisfactory agreement, you still have the right to proceed with your contested hearing. The judge will hear your case and decide it based on the evidence and arguments presented. Remember, in some jurisdictions, negotiation may be limited. For example, in Washington, red light camera tickets are processed like parking tickets and may not be negotiable. However, you can still request a mitigation hearing to ask for a fine reduction. In many jurisdictions, there is no insurance impact from a red light camera ticket. As a result, those tickets do not affect your driving record or insurance in Washington. So negotiation is less critical than for officer-issued moving violations. In summary, negotiation is a valuable tool for resolving red light tickets quickly and favorably. Be prepared, respectful, and know your options. Even if you cannot get the ticket dismissed, you may be able to reduce the penalty or avoid points on your record. Chapter 10. Here comes the judge. In this chapter, we'll discuss what happens after your hearing, including how to interpret the court's decision, payment options, appeals, and record clearing. Here again, the examples are based on Washington state procedures and practical outcomes. The hearing is over. So now what? Whether you attended a contested hearing, submitted a written statement, or negotiated a settlement, it's important to understand what happens next. This chapter explains how to interpret the court's decision, your payment and appeal options, the consequences of failing to respond, and how to clear your record if you win. After all evidence and arguments are presented, the judge will decide and make findings of fact and/or conclusions of law. First, most hopefully, the judge can find it more likely than not that you committed the infraction. This is the civil equivalent of guilty in criminal court. Alternatively, the judge could find the evidence insufficient to prove you committed the infraction, and the ticket is dismissed. If you requested a mitigation hearing, the judge may mitigate the infraction and reduce your fine, but still find the infraction committed. The judge may announce the decision in open court on the record, or, if you submitted a written statement or appeared remotely, mail you the decision after the hearing. If the ticket is dismissed, there is no fine or penalty. You owe nothing, and the infraction does not appear on your driving record. In many jurisdictions, for most traffic infractions, a dismissal means the violation is removed from your record automatically. Since the infraction is not reported, your insurance should not be affected or impacted. If the ticket is upheld, you will usually have to pay the fine or possibly post a bond for an appeal. The court will provide instructions for payment, which can usually be done online, by mail, or in person. If you cannot pay in full, you may ask about payment plan options. In some cases, you may be able to attend traffic school to reduce the impact on your record, more common for moving violations. If you fail to pay, the court will impose additional penalties and may notify the Department of Licensing, leading to license suspension and referral to collections. This may also have additional negative consequences for your insurance rates. If you believe the judge made a legal error, you may appeal the decision. To do so, you will have to file a notice of appeal with the court within the deadline, usually 30 days. The appeals are heard in Superior Court, and the process focuses on legal errors, not new evidence. Filing an appeal may temporarily stay or stop the penalty from taking effect, but you must comply with all procedural requirements. If you fail to respond to your ticket, miss your hearing, or do not pay your penalty, the court will find the infraction committed by default, and you may have to pay additional penalties, e.g., an extra $52 penalty is added in Washington. Further, the Department of Licensing will be notified, and your license may be suspended. Unpaid fines may be sent to a collection agency, increasing your financial burden. If the ticket is for a moving violation and the finding is committed, your driving record may be implicated, points added, and your insurance rates potentially affected. In some states, like Washington, red light camera tickets are treated like parking tickets and do not appear on your driving record or affect insurance. As to clearing or sealing your record, typically dismissed infractions are generally removed from your record automatically. Your state may or may not have a formal expungement process for traffic infractions. Washington does not, but you can request a certified copy of your record to verify the dismissal. If a dismissed ticket still appears on your record, contact the court clerk or Department of Licensing to correct the error. If you cannot pay fines due to special circumstance such as financial hardship, you may request a hearing to explain your situation. Courts may reduce fines or set up a payment plan. If your infraction leads to a license suspension, you may be eligible for a separate administrative hearing to contest the suspension. Here are a few practical tips. First, keep and save all court documents, payment receipts, and correspondence. Follow up and confirm that the court and Department of Licensing have updated your record as appropriate. Monitor your insurance and check your rates at renewal. If a dismissed ticket appears on your record, contact your insurer with proof of dismissal. To summarize, after your hearing, pay close attention to the court's decision and your obligations. If you win, your record is clear. If not, act promptly to pay fines or appeal. Avoiding default judgments and license suspensions protects your driving privileges and financial health. Always keep documentation and follow up to ensure your record accurately reflects the outcome. Afterward. In conclusion, if you admit to running the red light, paying the fine is generally the simplest and fastest resolution, but it's not always the best option, especially if you're concerned about your driving record, insurance rates, or financial hardship. Paying the fine is the equivalent to pleading guilty. You accept the violation, pay the fine, and receive any associated penalties, such as points on your license and possible insurance rate increases. The benefit is it resolves the matter quickly and avoids the time and uncertainty of a court hearing. However, be aware that once paid, you cannot challenge the ticket further. Paying the fine may be the better option when have no defense and want a quick resolution. If you are not eligible for traffic school, mitigation, or other alternatives, the cost of contesting, any of your time involved and costs for fees and possible legal help, could outweigh the potential benefit. It's your call. As to contesting the ticket, if you have no legal or factual defense and admit you ran the light, your chances of dismissal are low. However, contesting the ticket by a written memorandum of points and authorities, contesting it in court, or requesting mitigation may allow you to ask for reduced fines, traffic school, or a lesser charge, especially if you have a clean record or can explain mitigating circumstances, e.g., emergency, financial hardship. You can obtain forms and templates online or from the court pertinent to these defenses. Be sure to attach exhibits backing up your defense. You may also wish to subpoena the officer who issued your ticket. You can usually find sample subpoena forms traffic infraction hearings from official court instructions and forms. Some courts provide a subpoena request form you can fill out and submit to the clerk, who will prepare the official subpoena for you. Always check with your local court for any specific requirements or to obtain an official version. Judges often have the discretion to reduce penalties even if you plead guilty or no contest. Pleading no contest, nolo contendere in fancy lawyer speak, is similar to pleading guilty in terms of consequences, but you do not formally admit guilt. In some jurisdictions, this can help if you're concerned about civil liability, though for traffic tickets, the practical difference is minimal. So contesting the ticket or requesting mitigation may be better when you want to try for a reduced fine, traffic school, or a lesser charge, which may help with insurance or points. It may also be a better option when you have financial hardship and want to request a payment plan or reduction, or when you want to keep your record as clean as possible, especially if you have prior violations. When it's worth challenging a red light ticket. It is often worth challenging a red light ticket in the United States, especially a camera-issued ticket, when certain conditions apply. Here are the main factors to consider. 1. You were not the driver. Camera ticket. If you were not driving the vehicle at the time, you can submit a declaration of non-responsibility or similar affidavit. If accepted, the ticket may be dismissed or a hearing scheduled. 2. The evidence is unclear or incorrect. If the photo or video does not clearly show your vehicle committing the violation, or if the license plate is misread, you have a stronger case for dismissal. If you can show you entered the intersection on yellow, or the camera captured an error, this is a valid defense. 3. Procedural or technical errors. Tickets can be dismissed if there are errors such as A. The notice was not mailed within the required time frame. B. The camera or its certification was not up to date. Or C. The required signage was missing or obscured. 4th, legal or factual defenses. If you stopped fully before turning right on red, and there was no turn on red sign, and the video supports your claim, you have a good chance at winning. Also, if you ran the red light due to an emergency, you may present this as a mitigating circumstance. 5. Financial or practical reasons. If the fine is substantial, or if you have multiple tickets that could lead to registration holds or other penalties, it may be worth contesting. If you have a clean record and are eligible for a deferral or mitigation, you might get the fine reduced or the ticket dismissed after a probation period. 6. Officer-issued tickets. If the ticket was issued by an officer and you believe the officer made a mistake, e.g., poor vantage point, you were in the intersection before the light turned red, you may have a better chance in court. Summary of situation and whether it's worth challenging. Not the driver, camera ticket. Yes, worth challenging. Evidence is unclear, inaccurate. Yes, worth challenging. Procedural, technical error. Yes, worth challenging. Emergency or legal defense. Yes, worth challenging. Officer issued ticket, valid defense. Yes, worth challenging. Clear evidence against you, no defense. Unlikely it's worth challenging. Camera ticket, only seeking fine reduction. Sometimes worth challenging and always worth asking to mitigate. The bottom line, it's worth challenging a red light ticket if you have a clear legal, factual, or procedural defense, or if you are not the driver. For camera tickets with clear evidence and no valid defense, contesting is less likely to succeed, but you may still request mitigation or a deferral to reduce the penalty. If you admit to running the red light and have no defense to present, emergency, hidden signage, blurry photographic evidence, you stop before the camera captured you entering the intersection, etc., paying the fine is faster and easier. However, appearing in court or requesting mitigation may still help reduce the penalty or keep points off your record, particularly if you have a good driving history or special circumstances. Most people who get traffic tickets do not contest them and simply pay the fine, even when they know it could end up costing them thousands of dollars in penalties and increased insurance rates over the next few years. If after reading this book you are still unsure about whether to challenge your ticket or not, consider consulting a local traffic attorney for advice tailored to your situation. I hope you found reading this book helpful and insightful. Your opinion matters. Please consider leaving an honest review on Amazon, PayHip, Goodreads, or any other widely used book review platform you might use. It only takes a minute and makes a big difference. Thank you for your support. Additional online resources. Chapter 1. Understanding Red Light Laws. https www.myimprov.com. Driving record. Ways get red light ticket dropped. https www.freeadvice.com. Legal how to beat a red light ticket. Chapter 2. The ticketing process. https www.finelaw.com. Legal blogs, law and life. Legal how-to fighting. Red light camera tickets. Chapter 3. Common defenses to red light tickets. https www.reddit.com. Your Seattle WA. Comments. 1DNT7. SY. Got a ticket from red light camera. How to proceed. Chapter 4. Gathering and organizing your evidence. https://www.finelaw.com/traffic/traffic tickets/how-to-fight-traffic tickets. 5 strategies that work.html. Chapter 5. Preparing your case. https kingcounty.gov n court district court courts jails legal system traffic vehicle citations photo enforced. https www.courts.org self-help traffic.going-traffic court fines. https www.mass.gov info details what to expect at a traffic ticket hearing. https kingcounty.gov n court district court courts jails legal system traffic vehicle citations respond to citation ticket. https www.seattle.gov courts somber tickets and payments camera tickets. Chapter 6. Court procedures. https kingcounty.gov in court district court courts jails legal system traffic vehicle citations photo enforced. https www.nolo.com legal encyclopedia free books beat ticket book chapter 7-2.html. https www.seattle.gov courts tickets and payments camera tickets. https www.cityofpuyallup.org FAQ ASPX QID equals 1. https www.reddit.com or Seattle comments 16 Mauer 5x5 2 red light traffic camera discussion / Chapter 7. Using legal precedents and authorities. https www.reddit.com or Seattle WA comments 1D NT7SY. Got a ticket from red light camera. How to proceed. https appleg.ua.gov RCW default ASPX. Site 40 6.63 075. 8 PS. 1 www.avo.com. Legal answers. 8I. Received a red light camera ticket in the city 015-24202. Intertemel. HTTP ap.leg.e wa.gov rcw default. ASP site 46.63 and full equals true. http kingcounty.gov in court, district court, courts, jails legal. System traffic vehicle citations, photo enforced. Chapter 8, drafting legal papers, https www.seattle.gov, Shona courts, tickets and payments, camera tickets. Chapter 9, negotiating with the other side, https www.heritagelaw.com, practice areas, traffic violations, what happens at hearings.html. Chapter 10, after the judge rules, httpo Snohomish County eda.gov/5966/traffic infractions. https://app.legwa.gov rcw default. ASPX site raster 46.20329. https www.gov driver licenses and permits, suspended license, requesting and preparing driver hearing. https://www.law.cornell.edu, regulations, Washington, WA, C3081011040. https www.kitsap.gov.dc pages infractions .espx. https Snohomish County wwa.gov/5966/traffic infractions. https Jurnchat www.co.kittitas.wa.usa uploads, documents, courts, upper tickets, traffic infraction motion for deferral.pdf. https www.cityofpuyallup.org document center view 12220 electronic deferral form Milton Municipal Court. https www.co.pacific.us courts NDC traffic infraction deferral program.pdf. https www.courtswa.gov forms AFARN forms contribute in form ID synxua. https://www.courtswa.gov forms defiron forms .static ID equals 14. https form files .justia.com PDF Washington 013891.pdf. https www.courtswa.gov forms fay forms .contribute form ID 46. https www SpokaneCounty.gov document center view 723 subpoena instructions PDF. https kingcounty.gov in court district court courts jails legal system forms. https www.kirklandwood.gov files shared assets public v3 municipal court subpoena Kirkland subpoena instructions civil.pdf. https Snohomish County .gov/5966/traffic infractions. https://mutcd.fmhwa.gov/kno_11th edition.html. Appendix A, glossary of terms, term and definition, affidavit, a written sworn statement used as evidence. Contested hearing, a court hearing where the defendant challenges the ticket. Deferred finding, a program allowing dismissal of a ticket after conditions are met. Discovery, the process of obtaining evidence from the prosecution. Infraction, a minor violation of traffic laws, usually punishable by a fine only. Mitigation hearing, a hearing where the defendant admits the violation but requests leniency. Prima facie presumption, a legal assumption that stands unless disproven by evidence. Appendix B, sample forms and templates. Infraction hearing request form. Snohomish County District Court form to handle your ticket without going to court. https chargejosh.snohomishcountywa.gov Document Center View BU 23647 Infraction Hearing Request by Mail form. Motion for deferred finding. City of Bainbridge Island. Deferred finding request form. https www.bainbridge.gov Form Center Court Forms 9 Deferred Finding Request Form 176 Affidavit of Non-Responsibility City of Seattle Municipal Court of Seattle Declaration of Non-Responsibility Traffic Camera Enforcement Program https www.seattle.gov Documents Departments Court 70 1-014 Declaration of Non-Responsibility 0310 2022 .pdf Appendix C Sample of a Washington Motion to Dismiss and Memorandum of Points and Authorities. State of Washington, City of Linwood, Citation Number 818400813552. Plaintiff versus Peter Ware, Defendant. Motion to dismiss and Memorandum of Points and Authorities and Declaration of Defendant. Defendant is contesting and moves to dismiss this ticket on the grounds that the evidence submitted by the prosecution is inadequate, insufficient, and not substantial enough to meet the prosecution's burden of proof by a preponderance of the evidence, and or to 1. Support the charges under the legal requirements and standards for a violation of CRB Section 46.61.055.3.a under the law, including without limitation that defendant failed to comply with the plain meaning of the language of RCW Section 46.61.055. 2. Prove plaintiff has complied with the prerequisites of RCW Section 46.64.170H and LMC 11.18B, requiring the placement signs in locations that clearly indicate to a driver that he or she is entering a zone where traffic laws are enforced by an automated traffic camera. Or 3. Support the charge under the legal requirements and standards for reliability when using a camera recording system or device. In addition, defendant is contesting this ticket on the grounds that the fine violates federal, state, and local law, including without limitation the ban on excessive fines set forth in the Eighth Amendment to the United States Constitution. The evidence is insufficient to show defendant did not stop before making a right turn on red. The evidence submitted in this case, including the video and images of this incident posted online at www.violationinfo.com, is misleading, misrepresents the true facts, and is insufficient as a matter of law to prove by and preponderance of the evidence a violation of RCW Section 46.61.055. The plain language of RCW Section 46.61.0553 A states that vehicle operators facing a steady circular red signal alone shall stop at a clearly marked stop line, but if none, before entering the crosswalk on the near side of the intersection, or if none, then before entering the intersection control area, and shall remain standing until an indication to proceed is shown. However, the vehicle operators facing a steady circular red signal may, after stopping, proceed to make a right turn, unless a sign posted by competent authority prohibits such movement. Vehicle operators planning to make such turns shall remain stopped to allow other vehicles lawfully within or approaching the intersection control area to complete their movements. Vehicle operators planning to make such turns shall also remain stopped for pedestrians who, or personal delivery devices that are lawfully within the intersection control area, as required by RCW 46.61.2351. Emphasis added. In fact, before proceeding to enter the crosswalk and intersection control area, defendant's vehicle was brought to a complete stop while facing the steady circular red signal, exactly as stated and as required under RCW Section 46.61.055.3.a. After stopping, the vehicle remained stopped and standing approximately 2 to 3 car lengths behind the crosswalk to allow other vehicles lawfully within or approaching the intersection control area to complete their movements before proceeding. Ident. There were no pedestrians or personal delivery devices within the intersection control area. Ident. There was no sign posted prohibiting such movement. Ident. Defendant's vehicle then followed the two cars in front of it, making a right turn into street traffic. Ident. The foregoing evidence is supported by the declaration of defendant below and is uncontroverted. The automated camera in this case is positioned, whether intentionally or otherwise, such that it does not capture any vehicle that may in fact be stopped and standing more than a few car lengths behind the crosswalk, as defendant's vehicle was, before it proceeds to make the right turn on red. The evidence is insufficient to establish defendant's vehicle did not stop before entering the crosswalk or intersection control area, or before crossing any clearly marked stop line. In fact, there is no evidence of the existence of a clearly marked stop line at all. See declaration of defendant below. There is no legal authority in RCW section 464.61055, or elsewhere for that matter that could be located, requiring a fixed or certain amount of any distance before an intersection control area within which a vehicle operator must stop before proceeding into the intersection control area. The law expressly authorizes a vehicle to proceed after stopping to make a right turn. Period. That is what defendant did. He stopped his car and was standing 2 to 3 car lengths behind the crosswalk before proceeding to follow the two cars in front of him to make a right turn. This evidence is uncontroverted, and based on the plain language of the statute alone, the case should be dismissed as a matter of law. The evidence is insufficient to establish compliance with the prerequisite signage requirements imposed by law. The law requires that each location where an automated safety camera is used shall be clearly marked by signs placed in locations that clearly indicate to a driver that the driver is entering a zone where traffic laws are enforced by an automated traffic safety camera. The evidence in this case is demonstrably insufficient to prove plaintiff has complied with automated traffic camera signage requirements under state and local law. RCW section 46.63170H requires that all locations where an automated traffic safety camera is used must be clearly marked at least 30 days prior to activation of the camera by placing signs in locations that clearly indicate to a driver that he or she is entering a zone where traffic laws are enforced by an automated traffic safety camera. Signs placed in automated traffic safety camera locations after June 7, 2012, must follow the specifications and guidelines under the Manual of Uniform Traffic Control Devices for Streets and Highways as adopted by the Department of Transportation under Chapter 47.36 RCW. In addition, Chapter 11.18b of the Linwood Municipal Code requires that each location where an automated safety camera is used shall be clearly marked by signs placed in locations that clearly indicate to a driver that the driver is entering a zone where traffic laws are enforced by an automated traffic safety camera. Not only do the photographs and video not provide any evidence of compliance with the legal signage requirements controlling the entire intersection, but also they are insufficient to show the condition of all the signal lights controlling the intersection, including cross traffic. The evidence in the case is insufficient to establish plaintiff's compliance with RCW section 46.64.170H and LMC 11.18b. In fact, it clearly shows there is no such signage clearly marked that follows the specifications and guidelines required by law, which could be seen by defendant as he approached the intersection after having stopped his vehicle. The automated traffic camera signage requirements are imposed for a reason, and the failure to give fair warning to drivers that automated traffic camera evidence will be used against them is a defense to prosecution of such tickets if no legally sufficient signage is proven to exist. The ticket should be dismissed. Third, there is no evidence of camera reliability as required by law. The camera recording device and entire system which produced the photographs in this case must be proven reliable by a preponderance of the evidence in order for the prosecution to meet its burden of proof. The trial court must exclude camera evidence unless it is established to be reliable by expert testimony that satisfies the requirements under Frye v. United States, 293 F. 1013, 1923, and Washington Evidence Rule, ER 702. See also State v. Copeland, 130 Wash. Second 244, 255 to 56, 1996, and Lakey v. Puget Sound Energy, Incorporated, 176 Washington 2D9, 09 Washington 2013. To admit camera evidence under these circumstances, the prosecution must prove to the trial court that the automated traffic camera is capable of producing reliable results. It can only do this by expert first-hand testimony. C. Anderson v. Axo, Nobel Coatings, Inc., 172. Washington 2nd, 593, 603, 2011, quoting State v. Riker, 123 Washington, 2nd, 351, 359, 1994. Unreliable camera evidence does not assist the trier of fact, and ER 702 excludes this type of evidence where the prosecution fails to prove strict adherence to methodology, proving the reliability of the evidence. See State v. Cawthron, 120, Washington 2nd, 879, 890, 1993. See also Reese v. Stroh, 128, Washington 2nd, 200, 306, 1995, citing Fry at 1014. The thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs. No sufficient evidence or explanation has been introduced in this case showing the reliability and adequacy of A. the condition of the camera system, B. the specific camera recording device's details, maintenance, and servicing, C. compliance with the legal requirements for the controlling intersection signage, including cross-traffic, D. the distance from signage to the intersection, E. compliance with law enforcement procedure manuals, F. compliance with instruction manuals for the camera recording system and devices, E. the yellow light clearance times, and G. the calibration of the timing and distance of the lights. Here, the specifics of any non-hearsay evidence form law enforcement. Any evidence other than first-hand testimony under penalty of perjury of the prosecution's witness is also inadequate and lacking in sufficient and substantial detail to prove by a preponderance of the evidence that the camera recording system is reliable and in compliance with the requirements of the law unless offered by an expert under ER 702. The substantial evidence test is used by the courts to determine whether the prosecution has introduced sufficient evidence to meet its burden of proof by a preponderance of the evidence. In determining whether substantial evidence supports the charge, the court must review the entire record to determine whether a rational trier of fact could find the essential elements of the infraction by a preponderance of the evidence. Because the legal requirements to establish liability using a camera recording device and system have not been met, the prosecution has not met its burden of proof by a preponderance of the evidence, and the evidence is too insubstantial and insufficient to support the charge. Inasmuch as the prosecution has not introduced other sufficient admissible evidence into the record to support the charge, no rational trier of fact could reasonably find, by a preponderance of the evidence, that defendant is liable for the ticket without additional clear and adequate evidence. There is not enough substantial evidence to establish liability for the ticket, and the ticket should be dismissed. The fine violates federal, state, and local law and is unconstitutional. The $124 amount of the proposed fine in this case is unconstitutional under the ban on excessive fines under the 8th Amendment to the United States Constitution and the Washington State Constitution. Traffic tickets and fines must comply with the 8th Amendment's ban on excessive fines. Pimentel v. City of Los Angeles, 974 If F 3rd-917, 9th Circuit, 2020. This right to be free from excessive governmental fines is not a relic relegated to the period of parchments and parliaments, but rather it remains a crucial bulwark against government abuse. The government cannot overstep its authority and impose fines on its citizens without paying heed to the limits posed by the 8th Amendment. At 925. The Supreme Court has held that a fine is unconstitutionally excessive under the 8th Amendment if its amount is grossly disproportional to the gravity of the defendant's offense. United States versus Bajakajian, 524 U.S. 321, 336 to 37, 118 Awam, Sinart, 2028, 141 LAD, second 314, 1998. To determine whether a fine is grossly disproportional to the underlying offense, four factors are considered. 1. The nature and extent of the underlying offense. 2. Whether the underlying offense related to other illegal activities. 3. Whether other penalties may be imposed for the offense. And 4. The extent of the harm caused by the offense. See United States versus $100,348 in U.S. currency, 354 F. 3rd Series, 1,110, 1,122, Ninth Circuit, 2004, enunciating the Bajakajian factors. While these factors have been adopted and refined by subsequent case law in this circuit, Bajakajian itself does not mandate the consideration of any rigid set of factors. United States versus McBee, 339, F. 3rd-1013, 1016, Ninth Circuit, Itsun Samyan Eid, at 921. Considering the Bajakajian factors, plaintiff's initial red light camera fine of $124 is grossly disproportional to the underlying offense, and it is greater than the limitation on the amount of the monetary penalty of a fine issued for other parking infractions within the city under LMC Section 11.18.04, which states 11.18.04 infractions processed. Infractions detected through the use of automated traffic safety cameras shall be processed in the same manner as parking infractions, with a monetary penalty no greater than the amount of a fine issued for other parking infractions within the city. Ordinanza, 2789, Section 1, 2009, Ordinance, 2642, Секція 1, 2006 року. V. Conclusion. The evidence submitted by the prosecution is inadequate, insufficient, and not substantial enough to meet its burden of proof. The prosecution has failed to support the charges under the legal requirements and standards for a violation, RCW Section 46.61.055, including without limitation that defendant failed to comply with the plain language of RCW Section 46.61.0553A. Plaintiff has not submitted a shred of evidence demonstrating it has complied with the prerequisites of RCW Section 46.64.170H and LMC 11.18B, requiring the placement signs in locations that clearly indicate to a driver that he or she is entering a zone where traffic laws are enforced by an automated traffic camera. There is no competent and reliable evidence to support the charge under the legal requirements and standards for reliability when law enforcement is using a camera recording system or device. Finally, the fine violates federal, state, and local law, including without limitation the ban on excessive fines set forth in the Eighth Amendment to the United States Constitution. The ticket should be dismissed. Declaration in support of motion to dismiss. 1. I, Thomas Paine, hereby declare and state as follows under penalty of perjury, under the laws of the state of Washington, that the following is true and correct to the best of my knowledge. 2. I have reviewed the evidence submitted in this case, including the video and images of this incident posted online at www.violationinfo.com. On the date in question, I pulled up to the intersection and brought my vehicle to a stop behind the crosswalk and behind two or more cars in front of me while facing the red light. 3. After coming to a stop, I remained standing approximately 2 to 3 car lengths behind the crosswalk to allow other vehicles lawfully within or approaching the intersection control area to complete their movements before I proceeded. I then followed the 2 cars in front of me, proceeding to enter the crosswalk and intersection control area and making a right turn into street traffic. 4. There were no pedestrians or personal delivery devices within the intersection control area. There was no sign posted prohibiting such movement. 5. There was no line that I could see on the street in front of me other than the crosswalk lines. There were no signs that I could see indicating I was entering a zone where traffic laws are enforced by an automated traffic safety camera. I declare under penalty of perjury under the laws of the states of Washington that the foregoing is true and correct. Dated May 5th, 2021. / Thomas Paine. Name Thomas Paine. Appendix D, Washington State Useful Resources. Washington State Courts and Traffic Ticket Information. Washington State Courts Traffic Infraction Information. Official site with information on traffic infractions, hearing requests, and forms. www.courts.wa.gov. Washington State Department of Licensing DOL. For driver's license records, infractions, and driving history. www.dol.wa.gov. Local municipal courts. Many cities have their own municipal courts with specific procedures and forms. Check your city's official website for court contact information. Red light camera ticket specific resources. City of Seattle. Red light camera program, information on camera locations, how to view your violation video, and CONUS procedures. www.seattle.gov/transportation/red light cameras. Red light camera FAQs, Washington State overview of laws, penalties, and rights related to automated traffic enforcement. www.wa.gov. Sample legal citations for Washington State. RCW 46.6105, Obedience to Traffic Control Devices. RCW 46.63075, Presumption of Registered Owner as Driver for Camera Infractions. RCW 46.63170, Automated Traffic Safety Camera Requirements. RCW 46.63140, Procedures for Contesting Infractions. Washington State Manual on Uniform Traffic Control Devices, MUTCD. Standards for Traffic Signals and Signage, mutcd.fhwa.gov. Washington State Bar Association, Traffic Law Section. For legal updates and attorney referrals, www.sba.org. Appendix E, Sample Generic Motion to Dismiss and Memorandum of Points and Authorities. Name of state, name of municipality, name city plaintiff versus John Doe, defendant, citation notice, number XXX, motion to dismiss and memorandum of points and authorities, and declaration of defendant, contesting the automated traffic safety camera evidence. Motion to dismiss and memorandum of points and authorities. Defendant is contesting and moves to dismiss this ticket on the grounds that the evidence submitted by the prosecution is inadequate, insufficient, and not substantial enough to meet the prosecution's burden of proof by a preponderance of the evidence, and or two, 1, support the charges under the legal requirements and standards for a red light camera violation under the law, including without limitation that defendant failed to comply with the plain meaning of the language of the traffic code. 2, prove plaintiff has complied with the prerequisites of the state and local traffic codes requiring the placement signs in locations that clearly indicate to a driver that he or she is entering a zone where traffic laws are enforced by an automated traffic camera. Or 3, support the charge under the legal requirements and standards for reliability when using a camera recording system or device. In addition, defendant is contesting this ticket on the grounds that the fine violates federal, state, and local law, including without limitation the ban on excessive fines set forth in the 8th Amendment to the United States Constitution. I, the evidence is insufficient to show defendant did not stop before making a right turn on red. The evidence submitted in this case, including the video and images of this incident, is misleading, misrepresents the true facts, and is insufficient as a matter of law to prove by and preponderance of the evidence a violation of the state and local law. The plain language of states that vehicle operators facing a red signal may, after stopping, proceed to make a right turn unless a sign posted by competent authority prohibits such movement. Vehicle operators planning to make such turns should remain stopped to allow other vehicles lawfully within or approaching the intersection control area to complete their movements. Vehicle operators planning to make such turns should also remain stopped for pedestrians who or personal delivery devices that are lawfully within the intersection control area as required by the law. In fact, before proceeding to enter the crosswalk and intersection control area, defendant's vehicle was brought to a complete stop while facing the steady circular red signal. exactly as stated and as required under the law. After stopping, the vehicle remained stopped and standing approximately 2 to 3 car lengths behind the crosswalk to allow other vehicles lawfully within or approaching the intersection control area to complete their movements before proceeding. There were no pedestrians or personal delivery devices within the intersection control area. There was no sign posted prohibiting such movement. Defendant's vehicle then followed the 2 cars in front of it, making a right turn into street traffic. The foregoing evidence is supported by the declaration of defendant below and is uncontroverted. The automated camera in this case is positioned, whether intentionally or otherwise, such that it does not capture any vehicle that may in fact be stopped and standing more than a few car lengths behind the crosswalk, as defendant's vehicle was, before it proceeds to make the right turn on red. The evidence is insufficient to establish defendant's vehicle did not stop before entering the crosswalk or intersection control area, or before crossing any clearly marked stop line. In fact, there is no evidence of the existence of a clearly marked stop line at all. See declaration of defendant below. There is no legal authority requiring a fixed or certain amount of any distance before an intersection control area within which a vehicle operator must stop before proceeding into the intersection control area. The law expressly authorizes a vehicle to proceed after stopping to make a right turn. Period. That is what defendant did. He stopped his car and was standing 2 to 3 car lengths behind the crosswalk before proceeding to follow the 2 cars in front of him to make a right turn. This evidence is uncontroverted, and based on the plain language of the statute alone, the case should be dismissed as a matter of law. The evidence is insufficient to establish compliance with the prerequisite signage requirements imposed by law. The law requires that each location where an automated safety camera is used shall be clearly marked by signs placed in locations that clearly indicate to a driver that the driver is entering a zone where traffic laws are enforced by an automated traffic safety camera. The evidence in this case is demonstrably insufficient to prove plaintiff has complied with automated traffic camera signage requirements under state and local law. State and local laws require that all locations where an automated traffic safety camera is used must be clearly marked, indicating to a driver that he or she is entering a zone where traffic laws are enforced by an automated traffic safety camera. Signs placed in automated traffic safety camera locations must follow the specifications and guidelines under the Manual of Uniform Traffic Control Devices for Streets and Highways as adopted by the Department of Transportation. Not only do the photographs and video not provide any evidence of compliance with the legal signage requirements controlling the entire intersection, but also they are insufficient to show the condition of all the signal lights controlling the intersection, including cross traffic. The evidence in the case is insufficient to establish plaintiff's compliance with state and local laws. In fact, it clearly shows there is no such signage clearly marked that follows the specifications and guidelines required by law, which could be seen by defendant as he approached the intersection after having stopped his vehicle. The automated traffic camera signage requirements are imposed for a reason, and the failure to give fair warning to drivers that automated traffic camera evidence will be used against them is a defense to prosecution of such tickets if no legally sufficient signage is proven to exist. The ticket should be dismissed. Third, there is no evidence of camera reliability as required by law. The camera recording device and entire system which produced the photographs, in this case, must be proven reliable by a preponderance of the evidence for the prosecution to meet its burden of proof. The trial court must exclude camera evidence unless it is established to be reliable by expert testimony that satisfies the requirements under either Fry v. United States, 293 F. 1013, 1923, or the more recent Dober v. Merrill, Dow Pharmaceuticals Inc. 509 U.S. 579, 1993, and the state rules of evidence. To admit camera evidence under these circumstances, the prosecution must prove to the trial court that the automated traffic camera can produce reliable results. It can only do this by expert first-hand testimony. Unreliable camera evidence does not assist the trier of fact, and the evidence rules exclude this type of evidence where the prosecution fails to prove strict adherence to methodology, proving the reliability of the evidence. The thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs. Fry at 1014. No sufficient evidence or explanation has been introduced in this case showing the reliability and adequacy of A. The condition of the camera system, B. The specific camera recording device's details, maintenance, and servicing, C. Compliance with the legal requirements for the controlling intersection signage, including cross-traffic, D. The distance from signage to the intersection, E. Compliance with law enforcement procedure manuals, F. Compliance with instruction manuals for the camera recording system and devices, E. The yellow light clearance times, and G. The calibration of the timing and distance of the lights. Here, the specifics of any non-hearsay evidence form law enforcement. Any evidence other than first-hand testimony under penalty of perjury of the prosecution's witness is also inadequate and lacking in sufficient and substantial detail to prove by a preponderance of the evidence that the camera recording system is reliable and in compliance with the requirements of the law unless offered by an expert under the rules of evidence. The substantial evidence test is used by the courts to determine whether the prosecution has introduced sufficient evidence to meet its burden of proof by a preponderance of the evidence. In determining whether substantial evidence supports the charge, the court must review the entire record to determine whether a rational trier of fact could find the essential elements of an infraction by a preponderance of the evidence. Because the legal requirements to establish liability using a camera recording device and system have not been met, the prosecution has not met its burden of proof by a preponderance of the evidence, and the evidence is too insubstantial and insufficient to support the charge. Inasmuch as the prosecution has not introduced other sufficient admissible evidence into the record to support the charge, no rational trier of fact could reasonably find, by a preponderance of the evidence, that defendant is liable for the ticket without additional clear and adequate evidence. There is not enough substantial evidence to establish liability for the ticket, and the ticket should be dismissed. The fine violates federal, state, and local law and is unconstitutional. The amount of the proposed fine in this case is unconstitutional under the ban on excessive fines under the Eighth Amendment to the United States Constitution and the state constitution. Traffic tickets and fines must comply with the Eighth Amendment's ban on excessive fines. Pimentel v. City of Los Angeles, 974 F3rd-917, Ninth Circuit, 2020. This right to be free from excessive governmental fines is not a relic relegated to the period of parchments and parliaments, but rather it remains a crucial bulwark against government abuse. The government cannot overstep its authority and impose fines on its citizens without paying heed to the limits posed by the Eighth Amendment. 8 at 925. The Supreme Court has held that a fine is unconstitutionally excessive under the Eighth Amendment if its amount is grossly disproportional to the gravity of the defendant's offense. United States v. Bajikajian, 524 U.S., 321, 336-37, 118 Escunate, 2028, 141 L. and 2nd 314, 1998. To determine whether a fine is grossly disproportional to the underlying offense, 4 factors are considered. 1. The nature and extent of the underlying offense. 2. Whether the underlying offense related to other illegal activities. 3. Whether other penalties may be imposed for the offense. And 4. The extent of the harm caused by the offense. See United States v. $100,348 in U.S. currency, 354 F. 3rd Series 1110, 1122, 9th Circuit, 2004, enunciating the Bajikajian factors. While these factors have been adopted and refined by subsequent case law in this circuit, Bajikajian itself does not mandate the consideration of any rigid set of factors. United States v. McBee, 339 F. 3rd-, 1013, 1016, 9th Circuit. Isonzamnyon, ed. at 921. Considering the Bajikajian factors, plaintiff's initial red light camera fine of is grossly disproportional to the underlying offense, and it is greater than the limitation on the amount of the monetary penalty of a fine issued for other parking infractions within the city under local law. Infractions detected through automated traffic safety cameras are to be processed in the same manner as parking infractions, with a monetary penalty no greater than the amount of a fine issued for other parking infractions within the city. Conclusion. The evidence submitted by the prosecution is inadequate, insufficient, and not substantial enough to meet its burden of proof. The prosecution has failed to support the charges under the legal requirements and standards for a violation of state and local red light camera laws. Plaintiff has not submitted a shred of evidence demonstrating it has complied with the prerequisites of the law, requiring the placement signs in locations that clearly indicate to a driver that he or she is entering a zone where traffic laws are enforced by an automated traffic camera. There is no competent and reliable evidence to support the charge under the legal requirements and standards for reliability when law enforcement is using a camera recording system or device. Finally, the fine violates federal, state, and local law, including without limitation the ban on excessive fines set forth in the Eighth Amendment to the United States Constitution. The ticket should be dismissed. Declaration in support of motion to dismiss. 1. I, J. Doe, hereby declare and state as follows, under penalty of perjury, under the laws of this state, that the following is true and correct, to the best of my knowledge. 2. I have reviewed the evidence submitted in this case, including the video and images of this incident posted online. On the date in question, I pulled up to the intersection and brought my vehicle to a stop behind the crosswalk and behind 2 or more cars in front of me while facing the red light. 3. After coming to a stop, I remained standing approximately 2 to 3 car lengths behind the crosswalk to allow other vehicles lawfully within or approaching the intersection control area to complete their movements before I proceeded. I then followed the 2 cars in front of me, proceeding to enter the crosswalk and intersection control area and making a right turn into street traffic. 4. There were no pedestrians or personal delivery devices within the intersection control area. There was no sign posted prohibiting such movement. 5. There was no line that I could see on the street in front of me other than the crosswalk lines. There were no signs that I could see indicating I was entering a zone where traffic laws are enforced by an automated traffic safety camera. I declare under penalty of perjury under the laws of this state that the foregoing is true and correct. Date, /J. Doe, name J. Doe.